Mr. Rowe.
Thank you, my Lord. May I start with the promised answer to Lord Trinity's question about how the Municipal Corporations Act, when it first came into effect, dealt with people who were already serving in some capacity as councillors. The answer starts on page 698 of the electronic record with the long title of the Act, an act to provide for the continuation of the city and borough corporations, for the erection of certain other municipal corporations, and for the consolidation and reform of laws affecting local government. So it comes into effect, well, it's enacted in the context of there already existing certain corporations. If we then go down to section 3 on page 701, we can see that what the Act did was to continue the municipal corporations established under the provisions of the written law set out in the first schedule and known by the names mentioned in that schedule. Those were corporations that had been created under previous acts concerning local government. And then section 4 establishes several new municipal corporations, bearing names, etc., as set out in the second schedule. There's then provision at section 5 about where it applies to, and we then get fairly quickly into what we've already looked at as regards sections 11 and 13, the mechanism for the election of councillors and aldermen. But there's one provision I wanted to draw the Board's attention to in particular, and that's at page 714, section 19. Subsection 1, each alderman or councillor elected before and holding office in a corporation at the commencement of this Act shall, so long as he continues to be qualified to hold such office under this Act, hold office in that corporation until the date when he would have ceased to hold office if this Act had not been passed.
So in section 11, whether it's a matter of the interpretation of a language or just a matter of practical reality, section 11 only did apply to people who were going to be elected after the commencement of the provision.
Certainly the provision in section 11 that says your term of office is 3 years from the date when you were elected.
Yeah.
So in a sense, we would submit that the existence of section 19 is rather a point in our favour. Parliament felt it necessary to say that there was a carve-out from what would otherwise have been the effect, namely that the term simply changed to one of 3 years from when you were elected. If you were elected under some previous arrangement, no, you carry on as if this Act had never been passed. And Parliament could have done that with the present amending Act. It could have said,
yes, if it had been transitional,
affects the meaning that my learned friend says it has anyway. It could have said this doesn't affect it if you're already a councillor. It doesn't affect you.
Yeah.
Paraphrasing. So, as I was saying before the short adjournment, and I'm sure you should have the point, we respectfully submit that there isn't really any ambiguity in the wording of the amending Act.
Sorry, how would that have worked in the present case? Why would it have been appropriate to include? Because his case is that they ceased to hold office at the beginning of December without anything being expressed. So what provision are you imagining would have been included on the appellant's case?
On the appellant's case, simply a provision that said that this does not apply. If I'll answer it this way: if our learned friends are right that the true parliamentary intention is that this is all prospective as regards the term,
as regards the incumbent,
as regards the length of terms, it's prospective in the sense that it doesn't affect anybody who's an incumbent. So an incumbent, our learned friend's case is that Parliament's intention was that people who already were councillors and aldermen, having been elected on a 3-year term, would cease to be such at the end of that 3-year term.
Yes.
And my point is that that's not what we say. First of all, that's not what the wording of the Act says, and secondly, we say that if Parliament had intended that to be the consequence. If it had intended that the regime governing how long you hold office is the regime that was in force when you took office, not the regime we're now bringing in, it would have said so, just as it did in Section 19.
It was 19, presumably what 19 was addressed to was that otherwise the effect of the Act was that they would cease to hold office.
Not necessarily. Section 19 might have been.
Well, if they will continue to hold office, notwithstanding.
Yes, but only until the date when he would have ceased to hold office if this Act had not been passed.
But you're presenting Section 19 as a carve-out from Section 11, and it isn't necessarily. It is equally consistent with Section 11 only having prospective effect and then having to cater separately for the existing councillors. So at best for you, it's neutral.
Well, I mean, as your Lordship will have noticed from its absence from any mention in our case, it doesn't form a central part of our argument. We say the wording is plain, but I'm not sure I concede it's entirely neutral. I mean, I accept, obviously, if you start from the premise that our friends are right about the meaning of Section 11, then Section 19 could be seen that way. But one's trying to read the whole thing and work out what Section 11 means, or more accurately, in this case, what the amending Act means.
What was the term of office before this Act was passed?
That I don't know, but
because,
I'm sure to be prompted and told.
As I see number 19, it's effectively saying, well, the term of office in here is different from what was there before this Act was passed. So for the avoidance of doubt, this Act doesn't affect the terms of office of those who are already in post.
Yes, that's a supplementary question we ought to have anticipated. We'll endeavour to give you an answer. But may I then, my Lord, just move on through the argument, essentially, as I say, following the scheme of our printed case. I don't think I need to deal at much length with the so-called secondary legislative materials to which our learned friends refer in their printed case. We deal with this at page 412. But it didn't feature very strongly in our learned friends' oral presentations, and rightly so in our respectful submission. But the point that was made in the printed case was that you could look at the Hansard record and see that it clearly wasn't intended to have the effect that we say it had. But there's been no serious attempt to meet criteria for citation of Hansard, and in any event, the fact that even if one does refer to Hansard, there's really nothing there in our submission that supports the appellant's case. This is not a classic case for reference to Hansard, where there is not only the gateway, because the provision is ambiguous or obscure or absurd, and you've got various other requirements met, but also that there's actually something useful that can be seen in Parliament being said about the effect. It's an argument from silence. Nobody in Parliament said this, therefore you should accept our construction. But in my submission, that's just not a line that's open to the appellant. That then takes me to the...
Well, before you get on to the next, just before we leave the text of the Act altogether, are you going to deal with the point that on your construction, incumbent councillors found themselves required to serve an additional year on pain of a fine?
Yes, I was going to deal with that in the context of the presumption against retrospectivity, but I certainly won't.
I'll be patient. Don't worry.
No, not at all. I will get to that. And I will also deal with your Lordship's point about the possible scope for manipulation that the Act may give, and to the government of the day, and what, in terms of when it brings the Act into force, and what that tells us, if anything, about the meaning. But so far as the principle of legality is concerned, our first submission in that context is that that's of no assistance if we're right that the Act is unambiguous. It's a little difficult to answer this point because, respectfully, we would submit that the way in which the case is argued by the appellant shifted from time to time in the course of my friend's presentation. It wasn't entirely clear exactly how it was being pitched. At one stage in my learned friend's argument, he said that while he accepted that Parliament did have the power to extend existing terms of councillors, that could only happen in exceptional circumstances where there was a reasonable justification for it. Well, that limitation, in my respectful submission, is one that doesn't find any basis in any of the principles to which my learned friend referred. What one needs, if one is to get anywhere with the principle of legality, which is the heading under which this point was mentioned, to identify, first of all, what it is that the principle of legality bites on, in the sense that what the fundamental principle is, which has to be brought to bear when considering what Parliament intended. But before we get there, we have our prior submission, which is that none of this matters if we're right. This is unambiguous. I come back to the question of the Constitution, because of course I accept that if the Constitution precludes Parliament from doing what we say it did, then that's a different matter altogether. But on the straightforward application of the principle of legality, the first point is, are we right that it's unambiguous? If we are, that's the end of the matter. And we've cited as an illustration of that the Supreme Court's recent decision in the Alistair case, where it was said, well, it's academic whether the rights that were being referred to there were or were not properly to be described as the sort of rights that attract the principle of legality, fundamental constitutional rights. And I don't think the Supreme Court decided, because it didn't need to, whether they were or were not rightly described as fundamental constitutional rights. But I hope it isn't unduly controversial to say that there was at least something in the proposition that they might be, the rights in the provisions of the Act of Union that the subjects in Northern Ireland, as it now is, should be on the same footing as regards matters of trade as the subjects of Great Britain. But none of that mattered, because the conclusion of the Supreme Court was that it was quite clear that Parliament had intended that those rights should be subject to the provisions of the European Union Withdrawal Act, which gave effect to the Northern Ireland Protocol. So the arguments about whether they were or were not fundamental rights and where they derive from was neither here nor there. And we've given in our case another perhaps less controversial, less politically controversial example, and that's trial by jury in defamation cases, which has been described, or was described historically as a fundamental constitutional right, but which has been done away with by Parliament in the Defamation Act. So all of these arguments about the principle of legality have as their foundation the suggestion that there is some ambiguity in the Act, or some respect in which one could read the Act, the amending Act, as having a different effect from that which we contend that it has.
The principle of legality will be engaged where you have a legislative statement which could unambiguously apply, but it isn't expressly applied. So, for example, an obligation that a taxpayer shall disclose on notice from HMRC all documents relating to a particular tax claim. I mean, that is unambiguous. It's all documents, but it would not be taken to include privileged documents without express provision.
Yes, well, of course I accept that the degree of, I mean, there's, for the purposes of argument, I take it in stages, but I accept, of course, one can't compartmentalize it completely. The extent to which you can say this is unambiguous, it perhaps is affected by the context. I mean, your Lordship's example is, with respect, a very good one, because in that context, you would ask whether there was an unambiguous intention on Parliament's part to override the privilege.
Right.
But the answer to that in the present case, I think, comes later in our submissions when we say, well, actually, what is the right here, which is said to be overridden. So that's the starting point on the question of the principle of legality. The role that's played by the Constitution in this regard is still, in our respective submission, a little uncertain on the appellant's case. Of course, we accept that if the Constitution says that Parliament can't do what we say Parliament did, then Parliament didn't do it. And the only question would be for Parliament to go back and decide whether to do it under the supermajority provisions. Of course, even then, of course, subject to review by the court. But the problem with that, and the fundamental problem, is that the Constitution doesn't itself mention local government at all. My learned friend, Mr. Ramrogan, began his submissions by saying that the expectation that voters had in 2019 that the people they were voting for in the local elections, voting against them, I expect in some contexts is how it's done, would be there. They had the expectation that they would be there for 3 years only, and that was part of the social contract that underpinned the system of local government. But of course the social contract is given effect in practical terms in the Constitution. It is to the Constitution that you look to see what, at least in legal terms, has been determined are the fundamental rights which cannot be overridden except by special provision. And the problem is that the Constitution, from the appellant's point of view, doesn't in fact say anything about local government at all. And that's not an oversight. That's what we've mentioned in the case. That was commented on in a report on of the Constitution Commission in 1974 between the original Independence Constitution and the Republican Constitution. So this is not a case where our learned friends can point to any specific provision in the Constitution that protects the right that they say this enactment, if we're right about its construction, overrides. They are driven back to saying essentially, well, look at the Constitution's reference to democracy and look at the Constitution's reference in Section 4 to the right of political expression. But that's simply a course which we respectfully submit isn't open to them, really open to the board in the light of authority. The position is, if it ever was in doubt, is now entirely clear in our respectful submission, and we've cited the relevant authority at paragraph 21 of our case. And in particular the board's dictum in the Suraj case, general notions of a sovereign democracy and constitutional supremacy cannot be separated or untethered from the specific provisions of the Constitution. And that, in our submission, is a complete answer to any reference to the Constitution in all of this. And we do respectfully stand by the point that it would be compatible with the notion of Trinidad and Tobago as a democracy for Parliament to decide to do away altogether with local government. I wouldn't wish to be misunderstood to be saying that's what the government thinks ought to be done, no. Or to be saying that would be politically acceptable. But the question, for present purposes, is whether it would be legally permissible if the government would have to take all the political consequences of it if it persuaded Parliament to do it. But would it be legally permissible to do it? And our respectful submission is that it would. And the reason it would is that the framers of the Constitution have left the question as to what, if any, local government there ought to be, and if there is to be such a thing, what shape it should take, entirely to Parliament. And there's nothing inconsistent, there's nothing incompatible between that and the notion of Trinidad and Tobago as a democracy and as a place that has the rights set out in Section 4 of the Constitution, including the right of political expression. The essence, we respectfully submit, the essence of democracy is the notion that the sovereign government is elected by the people, whether directly or, as in a Westminster Constitution, indirectly through election to the legislature. And one can't say that because a particular tier of government is taken away, that's subordinate to that, the state, either that the state ceases to be a democracy, properly so called in legal terms, or the right of political expression has been taken away. And we set out in our case a whole series of examples in the constitutional history of the United Kingdom where numerous areas have been, over time, reallocated by Parliament to different bodies. In some cases to locally elected bodies, in some cases to bodies elected by one of the constituent parts of the Union, in other cases to bodies that are entirely outside the jurisdiction altogether, the European Union, much of whose law was made by the European Commission, which wasn't elected by anybody, but Parliament decided that that was the appropriate thing to do, and then, of course, we all know what happened after a while of that being the state of play. And the Alistair case I mentioned earlier is another example of that, of course, where Parliament has decided that the laws in Northern Ireland in relation to a number of matters should be aligned with those of the European Union, even though there's no voice at all in the European Union on behalf of the United Kingdom or Northern Ireland. All of those, they merely illustrated my submission that there is nothing in any of, there's nothing in the present case about the reorganisation that we respectfully has been achieved by this amendment that puts into question the notion of Trinidad and Tobago as a democracy or as a place where one can exercise the right to freedom of political expression. These are all matters that are in Parliament's hands. And that being so, if it would be possible for Parliament to do away altogether with local government, it can hardly be unconstitutional for Parliament to make we respectfully submit, modest alteration to the practical arrangements by saying that the term of office of existing office holders is extended by 1 year, notwithstanding that they were elected on the basis that they would serve for 3, as opposed to the 4 that they've now been told that they stay for. In any event, even if there was a constitutional right along the lines that our learned friends sought to articulate, respectfully we submit they didn't articulate it terribly clearly, which is not an ad hominem criticism of a learned friend, but a reflection of the difficulty of the argument. What actually is the constitutional right? But even if there was one, it wouldn't be an absolute constitutional right. All constitutional rights, with perhaps one or two absolutely fundamental exceptions, like fair trial, are by their nature rights which can be to some extent impinged upon by legislation in the public interest, and it's for Parliament to judge what the public interest requires, unless one gets to the point of saying this actually infringes the Constitution. And in our submission, to say that a 1-year postponement somehow strikes at the heart of democracy in Trinidad and Tobago is unrealistic in our respect. So, in those circumstances, we say there's nothing in the constitutional argument. And it's not really good enough to assert in rather broad terms that there's a constitutional recognition of the importance of democracy. One does need to look, in our respectful submission, at what the Parliament what the Constitution has actually said about how that's to operate in practice. And the Constitution is specific about aspects of parliamentary democracy in Trinidad and Tobago, but at the level of the national Parliament. And it says nothing, as I've said, about local government, which is a strong indication that there is no specific constitutional right.
I mean, that is an issue which clearly doesn't really arise on this appeal, does it? If there was a proposal to abolish all directly elected or all elected local government, that would raise. I mean, one only has to see recital C to the Constitution to think that it might raise an issue.
Yes, one can see that if that were the proposal, then one could mount an argument that was inconsistent with the implicit nature of the Constitution. But I wouldn't concede that it would be a powerful argument or an argument that would succeed, because one would be driven back to the fact that the Constitution says that it's for Parliament to make to legislate for the peace, order and good government of Trinidad and Tobago. And if Parliament's judgment is that it isn't required, then that would be a Parliament's judgment. But I agree, I don't need to go as far as to persuade you that argument would be decided one way or the other. But merely discussing the point throws into pretty sharp relief the relatively modest nature of what's going on in the present case, in my submission. Because, of course, the whole point of raising this, as I understand it from where our learned friends put the argument, is to say, well, this construction put forward by the respondents so interferes with the rights or the way of doing things that is recognised by the Constitution that it can't be right. Parliament can't be taken to intend to do it. The trouble is that it's not in the Constitution. And that really leads me to my point about the common law. I think I understood our learned friends to accept that there isn't a common law right to vote, although our learned friends sought to distinguish the Muhan case by saying, well, that wasn't about elections to a representative body. That, in my submission, isn't really a sufficient point of distinction. It is plain in our submission that there is no common law right to vote. There's a constitutional right in Trinidad and Tobago to have Parliament elected, because those are provisions expressly set out in the Constitution. Perhaps implicitly in the United Kingdom there's also such a provision, and I think somewhere in our case quoted a talk that was given by one of your lordships about that and what might happen in certain extreme circumstances. Might the judges in certain extreme circumstances constrain parliamentary sovereignty to a certain extent to protect that? But there isn't a common law right to vote in itself. And the difficulty with any argument based on the principle of legality in our submission runs into first of all, that it runs into the fact that the Constitution itself doesn't say that there is a right to vote in local elections, or anything about local elections. Because really, the principle of legality, and this is why we say, query whether it really applies in this case at all, is a principle which has been devised in the United Kingdom, and I think in Australia as well, to cater for situations where you don't have a constitution in which fundamental rights are enumerated. It's true, of course, that in the United Kingdom we now have the Human Rights Act, which enumerates and incorporates in its way certain rights that are set out in the European Convention. But of course those are only certain rights and by no means reflect all of the rights that we in the United Kingdom regard as fundamental. Trial by jury, for example, isn't there?
Would it not be true to say that even if a right is statutory in origin, nonetheless, if it's an important right, the courts may hesitate to construe legislation as abrogating it? I have in mind, for example, the discussion in the HS2 case about...
It was of Article 9 of the Bill of Rights, which you have in mind.
Yes, Article 9
yes.
of the Bill of Rights. And the point was made there that quite a lot of the rights which in this country are regarded as particularly important are statutory in origin, whether it's Magna Carta or the Act of Settlement or the Bill of Rights or the acts establishing the franchise. And one wouldn't readily construe or impute to Parliament an intention to take away those rights.
Yes, I mean, well, one is always when construing any piece of legislation conscious of the context, and one therefore needs to ask, as it's put in the passage from Lord Sales's piece that we quote in our case on page 415, one asks whether the supposed fundamental right can plausibly be taken to have had such a level of acceptance among parliamentarians as to form part of the context in which they meant to act. In other words, because I mean, ultimately what one's saying when one applies the principle of legality is Parliament can't have meant to do this by the general words it's enacted. As in Lord Richard's example of the tax legislation, disclose all of your documents. Parliament can't have intended by those general words to have incorporated an override of privilege. But the difficulty with applying all of this in the context of a country with a written constitution which contains a list of enumerated rights is that, at least the starting point, is that you would expect that the enumerated rights reflect those rights which that society has decided are the fundamental rights. So query in our respectful submission to what extent the principle of legality really has a scope to operate. Because if it's not in the Constitution as a fundamental right, then it's got to be, in order for the principle of legality to work, it's got to be a right which is not so important that the Constitution makers thought to put it in the Constitution, but nevertheless so important that Parliament, when legislating, must be taken to have proceeded on the basis that it wasn't going to override that right except by express words. One would have thought the class of rights which are not constitutional but are important enough to fall into the within the scope of the principle of legality is a small or indeed non-existent one in our respectful submission. That's why I say it's rather dangerous to use the principle of legality in this context. I'm not sure, since Your Lordship asked the point about statutory rights, I mean, we do refer to the recent decision of the Supreme Court in the registration of children as British citizens case. And in that case, the court, in fact, said in fairly express terms that the principle of legality had no application. That's page 1354 in the record. I think this was Lord Hodge. on that page in the judgment, towards the bottom of the page F, there's a quotation, letter F, there's a quotation from the AXA General case, Your Lordship's summary of the principle of legality. Obviously, they're applying to a different issue about conferring on other bodies the power to do things, which doesn't apply here. But as you see, it goes on to say, because as is not disputed, we are not concerned in this appeal with fundamental common law rights, the special rule of construction, which is embodied in the principle of legality, has no application. In our respectful submission, if that's right, and since the Supreme Court appears to have said it is right, then it is right for present purposes, then we would respectfully submit that the principle of legality has no application in the present case, because there is no common law right to vote in local elections. The only right to vote was the right created by the 1990 Act. And that which Parliament conferred, Parliament can take away, and the principle of legality simply isn't engaged. But even if that's too absolutist a position to take, and your Lordships think that the principle of legality can be engaged in relation to a right which derives from statute, and I suppose it might be said, going back to the Alistair case, that the Act of Union is after all a statute, albeit a rather important one, then we would submit that the present case doesn't present you with a sufficiently clear right recognised, such as must be presumed to have been recognised by Parliament, so as to attract the rule of construction on which our friends rely. In other words, there's nothing in the whole corpus of law, whether it's the Constitution itself, whether it's the common law, or whether it's statute, which gives rise to the existence, as of the moment that the amending Act is being passed, of a right such that Parliament must be taken to have proceed on the basis that if it was going to override that right in any way, it would have done so expressly. We just don't get there in our respectful submission. And of course, in any event, we're not talking in the present case about overriding the right altogether. We're not in your Lordship's hypothetical example of an act that says local government is abolished. We're talking about a modest alteration to the terms of the arrangements, albeit one, as we accept, that does have the effect that people who have been elected for 3 years find themselves now sitting for 4 years, and conversely voters who, presumably there must be at least some who voted on the basis that they were prepared to stick whoever it was for 3 years, now find they're required to stick whoever it was for 4 years as their local councillor or alderman. We accept that, but that's the extent of it, and we're a million miles away from the hypothetical example of abolishing the whole system altogether. But as I say, once you accept that the whole system probably could be abolished altogether, then it's a bit difficult to say that this modest amendment to the system is unlawful.
Do you also say in that context that it's not necessarily adverse to the democratic ability of the electorate to influence how local government works, that the term of local elected officials should be longer rather than shorter? I mean, to take it to a greater extreme than is illustrated by this case, if one was only in for 1 year, you could probably have very little effect at all upon the way the appointed officers ran the show, and giving yourself a bit longer in power before you hope you're re-elected may actually increase rather than reduce your power to change things.
Well, yes, with respect precisely that. It's by no means obvious that the democracy at the local level is undermined by this amendment, if we're right about what it does. It's of course a notorious fact that politicians who are in their last days of office have less power than politicians who've just begun their term of office or who have some of their term of office still to run. I think perhaps I'm just articulating back to the board your lordship's point, but the elected officials might well be thought to be more liable to be persuaded to do things in a certain way if they're being told it by somebody who's going to be the counsellor for another 12 months than by somebody who's just about to demit office. It's a notorious fact of politics that governments, at the national level, that governments in their last few months are less effective than at the beginnings of their term, and that leads on, if I may, to the point. If I may, my lord, your lordship's point about the scope for manipulation, and whether there is, on that basis, some reason to construe the legislation differently, as only applying to future elections. I think we would accept that, of course, the ability of the executive through the Statute Act to decide when to bring the Act into force in respect of the extension of the term potentially presents scope for manipulation. I would certainly not want to be thought to be accepting that's what's happened here. I don't think it's in the record, though it was before the courts below, and we can supply it if necessary. But there was a fuller explanation given by the executive as to why it was considered appropriate to exercise the power in the present case, and it was to do with giving more time before the rest of the package came into force. But that's neither here nor there as far as the legal arguments are concerned, because it's, as I started by explaining, it's common ground that there's no challenge to the legality of the decision to bring the regime into force. But accepting that there is perhaps scope for manipulation because a government which can see that the local councillors of its party are liable to get chucked out might wish to prolong their term in office in the hope that things might improve, might use the power to bring it into force later, or conversely might decide to exercise the power to bring it, might decide to let the current election take place on the basis that things might get worse in future. One sees that. But to use that as a reason for construing the Act, the amending Act, to mean something differently from what, as we submit it, plainly means, it would rather be a case of swallowing a camel but straining at a gnat in our submission, because it's fundamental to the whole Westminster system at the national level that the government can decide, subject only to a long stop, when the general election shall take place. That, of course, was the position in the
well, it has to take place, I think, within 5 years.
Oh yes, that's why I said subject to that provision. It's got to be within 5 years. But it's a notorious fact, of course, that until the advent of the Fixed Term Parliaments Act, which of course has now gone, until that came in, it's a notorious fact that governments would use their power to dissolve Parliament or to advise the monarch to dissolve Parliament and call a fresh election for political purposes, which is why...
nothing to do with this legislation, because there's no equivalent power in this legislation. Isn't the point really this, that your case is that Parliament has contemplated that by this amendment the terms of incumbent elected officials, councillors and aldermen, can be extended without any recourse to the electorate. But Parliament has decided to give the government the power to decide whether or not that should be the case. That's the relevance of that in relation to the construction of this Act. So
yes.
It's down to the government to decide, by when it proclaims particular sections to be in force, whether incumbent councillors should remain in office or not.
Well,
that's quite an unusual provision, one would think, that the central government could decide how long to extend the term of office of elected councillors.
Well, I'm not sure it's especially unusual, my lord. Can
you think of a parallel?
Well, the Welsh example that we quote in our case, that's a decision of the Welsh ministers. That's not a decision of the Assembly.
Pursuant to primary legislation.
Yes, pursuant to primary legislation, I accept. But that's the primary legislation which gives the Secretary of State power in that case exercised under devolution by the Welsh ministers, to extend the term. So that's precisely the point of my submission. That's Parliament saying that the government may, in relation to local elections, decide that an election that was about to happen will no longer happen, and that the people who are in office will continue in office for a further period.
Yes, I see.
In reality, but what's happened is that Parliament has decided that for the future, subject to precise timing, this term of office should be extended, and therefore the wriggle room which government has within which to decide quite when, in general terms, will simply perpetuate a historically shorter period of office rather than bring in the extended one for which Parliament has voted.
Yes.
It seems to be, I don't know whether this is part of your submission or not, but on the face of it, to treat this as giving the government power to extend people's terms of office is slightly counterintuitive, bearing in mind its context and what Parliament's already decided should happen in due course.
Well, my Lord, yes, with respect, that's right. I address this simply to deal with the thought that the fact that the government might be able to use this legislation for political ends is a reason for saying that actually it doesn't bear the construction that we respectfully submit should be put upon it. But in my submission, that point doesn't go anywhere, and there's nothing surprising about, in other words, about the fact that Parliament should have legislated to say that when the government decides to bring in this piece of legislation, the term of office of councillors, including the ones who are in office, will be extended. That's not at all surprising in my respectful submission, and therefore there's no particular strained construction one needs to give to the legislation in order to make it have some other effect. So my Lord, I hope deals with the principle of legality. There was in that context just one other citation I wanted briefly to take the board to, if I may, and it's one that was cited below. It's on page 181. I don't think it's actually made it into the authorities, but the passage is set out below. It's just emphasising our point about Parliament, about the Constitution rather, not having put the subject of local government and how it should be organised and so on into the Constitution. And it's the quotation from what Lord Hoffman said in the Matadine and Pointu case in 1999. It's in a different context, of course, because it's about equality and discrimination. But it's the emphasised passage. What you're looking at here is, I think, our submissions to the Court of Appeal.
I'm sorry, where?
181, my Lord.
Yeah. 181, sorry.
The passage is referring presumably to the legislature, isn't it?
I think it's referring there. Yes, it's referring there to the fact that under that constitution, it's been left to the legislature to map out the boundaries of the principle of the equality of treatment.
Yeah.
The fact that going a few lines up from the emphasised passage, the fact that equality of treatment is a general principle of rational behaviour does not entail that it should necessarily be a justiciable principle, that it should always be the judges who have the last word on whether the principle has been observed. And my point is, respectfully, that may be something of an echo of that in the present case, where your lordships were pressed in general terms about the importance of local democracy in Trinidad and Tobago, none of which we question for an instant, but not provided, in our respectful submission, with any clear legal basis for saying that that general importance, which everybody acknowledges, leads to the conclusion that the provision that we're looking at means what the appellant says it means rather than what we say it means.
Well, Mr. Ramlogan appealed to the principle of a rule of law. I took him to mean that it's constitutionally desirable and proper in general that the operation, for example, of democratic local government should depend on legislation rather than on the exercise of a discretion by the executive.
Yes. Well, as a general proposition, we would of course accept that. But what doesn't necessarily follow from that general proposition that there is some legal ground for reading what we respectfully submit as the clear statement of Parliament that the word 3 shall henceforth be read as the word 4 in any other way. I mean, that's essentially our point. It's our answer to that is related really to our answer to the appeal to the preamble to the Constitution and to the appeal to the notion of Trinidad and Tobago as a democracy. One can't simply rely upon these general principles untethered from the specific ways in which the framers of the Constitution decided to give legal effect to the provisions or to the principles rather to which they refer, and the fundamental difficulty is that they didn't give legal effect at all to these principles in relation to local government. And
once the executive complied with the Act, the rule of law was maintained.
Yes, one looks at whether the rule of law has been in any way infringed. One looks at by looking at whether the executive has infringed any provision of any act. Well, it's common ground that the executive didn't do that by bringing the thing into force. The only question is whether you should read the Act in what we respectfully submit would be an unnatural way, by reading in a whole series of slightly problematic exceptions, so as to reach a conclusion that the rule of law has not been infringed. But, my Lord, this overlaps to some extent, I think, with our submissions about retrospectivity. And in that context, can I then turn to what we say about that? It's from page 416 onwards in our printed case.
I'm so sorry, page?
416, my Lord.
Thank you.
Now, we go on to I hope we fairly summarise there what the appellant complains about. I think it's fair to say it's the alteration after the fact of the duties that councillors and aldermen accepted when they took office when they stood for office in 2019, and 2, it's the what's described as the vested right to vote in local government elections that each elector enjoyed after the 2019 election. I mean, there's an anterior point here, which is what does the principle against retrospectivity actually mean in this context, and to what extent, if at all, is it engaged? And there is, in this context, a helpful passage and it's set out, and I can most conveniently take it from our submissions in the Court of Appeal, in the AXA general case. It's page 206. Because it's notorious, of course, that the description retrospective legislation can mean a variety of different things. And what we also see in the AXA case is the Supreme Court, I think it was, giving voice to the different, some of the different ways in which one can or cannot regard a law as operating retrospectively. And the first emphasised passage in particular, the position is different in the civil sphere. Obviously, in the criminal sphere, obviously, there is a strong presumption against any degree of retrospectivity. It's completely incompatible with the rule of law to find that something you did that was lawful at the time turns out to be unlawful and exposes you to criminal penalties. The position is different in the civil sphere. Changes in the law, even if resulting from prospective legislation or judicial decisions, will frequently and properly affect legal relationships which were established before the changes occurred. And there's reference to family law. And similarly, in the emphasised passage, a person who buys a house or a company that employs staff cannot expect the law governing the rights and responsibilities of homeowners or employers to remain unchanged throughout the period of ownership or employment. The same point could be made in respect of other types of right and obligation of a civil character. And the quote from the morality of law: if every time a man relied on existing law in arranging his affairs, he were made secure against any change in legal rules, the whole body of our law would be ossified forever. And we respectfully invite the board to keep that proposition firmly in mind when one looks at the extent to which this provision, if we're right about what it means, is truly retrospective. It doesn't purport to say, for example, that people who demitted office some while ago are brought back into office. It doesn't purport to invalidate anything that was done by anybody in the capacity as councillor or alderman in the past. On the contrary, it continues their terms in office. So it's retrospective only in the relatively limited sense that it alters the consequence of somebody being a councillor, and therefore it enables a person who stood for election in 2019 and got in to say, hang on a minute, this is not what I signed up for, I accept that. And it enables a voter who voted for that person to say, hang on a minute, I only voted for him or her on the basis that I'd be stuck with him or her for 3 years, not for 4. To that limited extent, I accept that there is a degree of retrospectivity in the Act, but it's far removed from some of the more extreme types of retrospectivity that one might come across. It's far removed in our submission from the Office Sheriff Young case, which, as your Lordships will recall, was a case about the new provision in the Arbitration Act that gave an arbitrator for the first time the power to strike out an arbitration claim on the grounds of want of prosecution. And the question was, what about if you'd been dilatory in the time before that came into force? Yeah. Of course, the answer that the House gave was too bad. Looking at it overall, yes, it does cover dilatoriness in the time before before the Act came into force. So the fact that something operates in a sense retrospectively is not in any event a reason for necessarily saying that it can't have the ordinary effect. All of these submissions about retrospectivity, rather like the submissions about the principle of legality, do depend first of all upon identifying with clarity some existing right which is unduly tampered with or affected by the measure that you're seeking to have read down effectively by reference to the principle on which you're relying, here retrospective application. And in our submission, that hasn't been very clearly done. But as I say, we do accept that there's an element of retrospectivity in all of this. But we say first of all that these points aren't compelling because this is not a context where one is actually looking at what can properly be described as vested rights. I mean, one hears in colloquial speech the term vested right or vested interest, but of course, to a lawyer, something vests when it becomes a concrete exercisable right. But the right to vote at an election in 3 years' time is not, we respectfully submit, a vested right in any meaningful sense. Of course, the right to vote at all is an important right, albeit one conferred in this context only by statute. But it can't realistically be said, we would submit, that there is a positive right to vote at a particular local election at a particular point in the future. But necessarily, when you go to the polling booths to exercise your right to vote, you do so on the basis that you're voting in the context of the system as it exists. And the system as it exists very plainly contemplates that sometimes terms of people you vote for might be extended beyond the term that you thought they were going to serve for when you voted for them. And our learned friends' illustrations from section 273 show that quite clearly. Time and time again, Parliament has said that existing terms shall be continued for longer, local elections shall be postponed. So it can't be said that there is some sort of, it's not put this way, but it can't be said there's some sort of legitimate expectation that the person you elect is only going to be there for 3 years, and therefore that's been thwarted by this legislation after the event. And as we say in the printed case, we respectfully adopt what Chief Justice Chagler said in the Bombay, the Chavan and the State of Bombay case. We've set it out at 417 in the case, and I needn't, I think, go to the text itself. It's difficult to accept the view that a voter has a vested right in the duration of the body which he elects. His vested right is the right to vote, and it may be that his vested right is also to stand as a candidate. The question as to the duration of the municipality is a question of policy, which is for the legislature to determine from time to time. When the election took place, undoubtedly by statute, the duration of the municipality was fixed for 3 years, but it was open to the legislature on grounds of policy to extend that period and fix the duration at 4 years and not at 3 years. That was the case on more or less all fours with the present one, in the sense that it was a change in the period by 1 year from 3 to 4 during a term that had started as a 3-year term. And of course, it's right to say, and this was developed by my learned friend, it's right to say that ultimately this is a question of fairness. But again, one has to ask, well, in whose hands is the decision as to what is fair placed?
The whole basis of these cases is not that a Parliament cannot do it. No, that's not the argument. The argument is that Parliament must do so expressly. That's the whole basis. There's no absolute prohibition on retrospective legislation. It's just that Parliament must do so expressly.
Well, that's right. Of course, our primary submission, as your lordships know, is that Parliament did do so expressly in the present case, because we say there really is no other sensible way to read what Parliament did. And every time one tries to read it in the way the appellant suggests, one runs into practical difficulties. One runs into the difficulty of saying, well, are we to insert some words as being as understood in brackets, but not as regards incumbents? And if so, are there then two parallel systems for a while in place? One runs into the difficulty that I identified earlier, which I do respectfully stand by as a submission, of saying, well, what exactly is meant by at the next election? At whatever moment the thing comes into force, what's meant by at the next election? Does it mean when the writ's been moved? Does it mean when nominations are in? Does it mean when the vote's been cast? Unless one can give a clear answer to that, one can't, as it were, rewrite the statute in accordance with this. So a starting point is that this is done expressly by Parliament, but as it were, the degree of...
I'm sorry, I don't quite know how you say it's done expressly by Parliament. I mean, what words in the Act do you point to say that Parliament has expressly stated that the terms of office of the incumbent councillors are to be continued for a year? That comes in by inserting those words by means of the proclamation while those councillors are still in office. There's nothing in the Act which expressly addresses this, is there?
There's nothing in the Act which expressly says, for the avoidance of doubt, this will apply to incumbent councillors. There's no equivalent of the Welsh minister's provision that we looked at. But my point about the point about the Welsh minister's provision is that what they did was to take an act that said the next election shall take place in 4 years after 2017, and it said 2000. It should be in 2017 and every 4 years thereafter. The act said the next election shall be 2017, and the next one after that should be 4 years, and so on. And they said change that to 2022. Whereas, of course, it would have been 2021, but for that change. And that's essentially all they did. And then they went on to say the term of existing councillors is accordingly extended by a year. And we place emphasis on the word accordingly because all they were doing was for the avoidance of doubt, we say, stating that was the consequence of saying the next election shan't happen until 2022.
I was just wondering where Parliament had expressly
in the present
addressed
of course,
the question of incumbent councillors.
It doesn't expressly talk about incumbent councillors because it doesn't need to in our submission, because if one goes back to the wording of the amending Act, first of all it says this Act shall come into operation on such date as is fixed by the President. That's section 2. Then it says the Municipal Corporations Act is amended by substituting the word for where you find the word 3, and the word quadrennial where you find the word triennial.
Well, you simply say it applies to all councillors and aldermen, not just a subset of them.
My Lord, that's right. I go back to the point I made before the short adjournment. If one arrives in Trinidad and Tobago from a foreign country and asks a well-informed citizen, what's the rule here about how long councillors serve? You're taken to the Act, and the Act says for 4 years. If you'd done that exercise on the 6th of November or the 5th of November, you'd have been taken to the Act and it would have said for 3 years. And that's, in my submission, that's really all there is to it. And the whole foundation of our learned friend's submission is that, well, that can't be right because there must be some overriding principle that means that Parliament must have intended to carve out an exception for incumbent councillors. And even though it didn't do so expressly, it must be that the default must be that it can't have meant to do that. Rather like your Lordship's tax example, it can't have meant to say privilege is taken away when it said this. So therefore, in the absence of anything specifically saying privilege is taken away, we read privilege as remaining. And I suppose on our learned friend's case, in the absence of anything saying incumbents continue, then they don't. But the problem with that is the starting point. The starting point is wrong in our submission because actually the plain wording of what they did do is such as to have the effect for which we contend. Yes, well, my learned friend, Mr. Das, just reminds me, and rightly so, that the other element of the words of Section 11, which is not insignificant, is the fact that it talks about the term of office being deemed to have begun on the day on which councillors were elected to office. Now that's, if you go back to Section 11, 4, the term of office shall be, as it was 3, now 4 years, and they shall retire together on the last day of any triennial, quadrennial period, the first of which shall be deemed to have begun on the day on which the councillors were elected to office. So there is, on the face of it, a deeming provision, and so the effect of the legislation after amendment is that they serve a quadrennial term, the first day of which shall be deemed to have begun on the day on which the councillors were elected to office.
I mean, it's not really a deeming provision, is it? I mean, one would have thought that the councillor's term of office did indeed begin on the day on which they were elected.
Well,
I mean, deeming is normally where you deem A to be B, even though it isn't.
yes, I suspect the reason it's been put in and put in that way is deeming is often that way, my Lord. Deeming is also where you deem it to be A when it's arguable that it could be B.
Yeah, I mean, it's just making it clear.
It's making it clear that it's that, not for example the day they were sworn in. Assuming they get sworn into office, or some other date, or the first meeting, or whatever it might be. But I mean, it's not. I don't hang my submissions on it. I just point out that there is. This is all about identifying what is the governing rule in relation to how long those who are now in office shall continue to serve, and the answer is given to the end of a 4-year term, starting from when they started to when they were elected. So, my Lord, yes, I do. So, we respectfully submit, as I say, that really the degree of retrospectivity here is the degree to which that principle can really bite is very limited, because that is all that is really being done. What about the? And as I say, we rely upon the Indian case, the Chavan case, from the perspective of the voters. They vote on the basis that they will be voting for people to remain in so long as Parliament wishes them to remain in office. And in that respect, it's no different. It's no more outrageously unacceptable in principle than the fact that in the United Kingdom, for example, anybody who voted in 2015 in the general election voted on the basis that people would be in force until 2020. But then Parliament decided otherwise. Perhaps that's a bad example because the Parliament decided otherwise in accordance with the Fixed Term Parliaments Act, as I recall. But Parliament then did away with the Fixed Term Parliaments Act anyway. The point is you vote on the basis that this is the system currently in place. You take the risk that the system might change. Just as to go back to the AXA example, when you set up a company and employ people, you do it on the basis that these are their rights today, but you don't insulate yourself against their rights becoming something different tomorrow if the government changes. Or you buy a house for some tenants, with some tenants in, and then you find that Parliament has said that you've got to build a fire escape. You can't say, well, that's not fair, it's retrospective. I didn't know that when I bought the house and the tenants in it. It's too bad. What about the position of individual councillors and aldermen? The general proposition that they find themselves in office for a year longer than they anticipated is true as the point of fact. We would respectfully question how much real practical detriment this provision has. One would have thought, in the case of most of the councillors, they would be, if they're like most elected politicians, relatively content that the need to submit themselves for re-election has been put off. But that may be an unduly flippant point to make. But more seriously, the Court of Appeal had it right in my submission when they said they may be presumably public-spirited people who won't necessarily have come into office on the basis that it was going to be 3 years and not a moment longer. And it is notable that nobody, apart from the public-spirited appellant, who is not himself a councillor, has come forward to say, well, look, I'm a councillor and I'm aggrieved by this, and my rights are being infringed. But let it be accepted that at least some councillors might be aggrieved about the fact that they're now required to serve for longer. And in fairness to our own friends, the evidence below, as your lordships might have picked up from the papers, did include one councillor who specifically said he'd arranged all his affairs around being 3 years in office and then being able to pick up his career as a prospective lawyer, which has now been interrupted by all of this. But what's the answer to that? Does that factor mean that the board should read the Act in the way that we say, otherwise it doesn't really fall to be read? Well, no, in our respectful submission. First of all, because just like the voters, the councillors who stood in 2019 stood on the basis that things might change. And there are numerous examples, and some of them are in the record from around the world, of precisely that happening. There's no... it's accepted that Parliament could change the duration of incumbent councillors in office. We gave the Welsh example of examples, I think, from one of the United States of America in the record. There are examples from the United Kingdom, other than just the Welsh example, where terms have been extended, and there's no dispute that it can be done. So that being so, why is it said that there should be, for the sake of the councillors, such a strong presumption that Parliament didn't mean to do that unless it spelled it out absolutely explicitly on the face of the statute? It's a little difficult in my submission to run both arguments at once for the appellant. On the one hand, the appellant says, well, whenever this is done expressly. Look at all these dozens of instances of parliaments around the world doing this expressly, saying expressly, or the term of incumbents is extended. On the other hand, the appellant says this is such an outrageous thing to do that Parliament can only have done it through express words. And there's a tension between those two, in my respectful submission. Because actually, when you stand for office, you do so on the basis that this has happened before. And it's happened before, specifically in Trinidad and Tobago, under the terms of the Act itself, as we saw from the various examples tacked on to Section 273. But the second answer, so the first point is that just like the voters who voted, the people who stood for election did so on the basis that the 3-year rule wasn't necessarily immutable, and it might catch them. And the second is that the burden is a minimal one because you are entitled to resign at any time, and we set the provisions out in our case at paragraph 34. If your lordships just want to look at it in the text one more time, it's page 716 in the record.
Certainly, I'd be grateful if you would explain to us how this would operate.
How the resignation would operate.
How the resignation would operate, at what stage the fine would be imposed, and to what extent you say that would be ameliorated or eliminated by any financial award commensurate with the office that person would in any event receive.
Yes. Well, the starting point is that while you are a councillor, you are entitled to remuneration for your service at the rate of $4,360 a month. we set this out at the bottom of page 417. I note we don't actually give the board reference to the text of the Act, which we ought to do, so perhaps we can undertake to supply that separately.
I would certainly welcome that for myself. Thank you.
Of course, my lord. So that's your remuneration, plus you get allowances of £2,810 a month to cover transport, subsistence and telecommunication. I'll need to check, unless either of my learned friends can help me, whether that's one of those allowances that gets paid irrespective of whether you prove you spent it on the relevant thing, or whether it's a maximum that you can reclaim against invoices showing that you've incurred those expenses. But either way, certainly at least the 4,360 per month is what you get while you're an incumbent councillor. Your right to resign is section 25 of the Act. That's page 716. A person elected to a corporate office may at any time by writing signed by him and delivered to the chief executive officer resign the office on payment of the fine provided for non-acceptance of the office. The reason it refers to non-acceptance is because it's, well, you'll see in a second, it refers to a scheme where if you get elected and then don't accept the office, you have to pay a fine. But then subsection 2, where a person resigns from a corporate office other than the office of mayor, the council shall forthwith declare the office vacant. And then there's noted there are provisions for what happens after that. And then subsection 4 provides for resignation on the grounds of ill health or because of change in residence or business, on the basis that you don't have to pay the fine.
And what is the consequence of having a fine imposed on you under this legislation?
The consequence of that is that the fine is recoverable as a civil debt. You see that at paragraph 22. I can pick up where the fine first comes in. Penalty for refusing to accept office. Every qualified person elected to a corporate office unless exempt either shall accept the office by making and subscribing the declaration required by this Act within 5 days after notice of election. That's probably why there's a deeming provision that says your 3-year term, or now your 4-year term, starts from when you were elected, lest it be thought it's from the day you signed the declaration. Or in lieu thereof, be liable to pay the corporation to which he's been elected a fine of $4,000. That's presumably designed to stop people from standing on the basis they refuse to take up their seats, as one supposes. And then there are certain exemptions. And then section 23, a fine payable to a corporation under section 22 is recoverable as a civil debt.
Does it lead to a by-election, or is the place then vacant until the next local government election?
I think it leads. My own friend thinks it leads to a by-election.
Okay.
That is.
I'm seeing nods on the other side.
Covered. Yes, I suspect that's covered in the succeeding provisions. Well, we can come back to it and find it, but I'm reasonably confident the answer is, since everybody thinks it is, that there is a by-election. Yeah. So, and there'll be provision for that, I'm sure, in the Act, which we can dig out. So, what does it come to? Well, I accept that it comes to this, that a councillor who is aggrieved by the fact that he or she stood for office on the basis that he or she was signing up for 3 years in office, faces the choice between either carrying on in office for the further period that Parliament has decreed, in this case a year, or resigning and paying the fine. But since the fine is $4,000 as against a monthly remuneration while the person continues in office of £4,360 per month, the practical effect is that the downside is you have to spend your last month, the net effect, you have to spend your last month as a councillor without remuneration. Given that I don't think it's controversial to say that generally the practice is that meetings are held monthly, that effectively means you have to go to one meeting and not get paid for it, which your lordships may think is not such a gross burden as to mean that one ought to strain to read the Act to mean something other than that which, respectfully, we submit it plainly means. So, my lord, essentially, that's the way in which we put matters. I haven't spent time looking at how the Court of Appeal decided the case, because this is one of those cases where it's a pure question of law and it comes before the board effectively de novo. So I can't derive a vast amount of support from the Court of Appeals, save this, that in circumstances where our learned friends are, albeit we would say in a way which is perhaps not entirely clear, are praying in aid notions of the existence of fundamental constitutional rights, or rights which are, if not actually in the Constitution, then akin to constitutional rights, sort of constitutional-ish sort of rights. The fact that both the High Court and the Court of Appeal don't appear to have been moved by those entreaties is perhaps indicative that your lordships would be on safe ground in saying that there isn't any such justiciable right which is engaged in the present case. But that's not to say, of course, that...
the Court of Appeal said in paragraph 76.
Let me look at it, my lord, and see.
It was the...
This was in, I think this was in the context, wasn't it, of their discussion of the principle of legality.
Yes, it was. And they didn't accept the submission about the applicability, the application of the principle of legality, but just in terms of the right,
yes,
they did say there was an attendant right that should be viewed as nothing less than basic and important. So you're not...
Well, we hesitate to conclude definitively the principle is inapplicable save and except where expressly stated or implicit constitutional rights are potentially engaged. That's in the context of the principle of legality and
yes,
dealing with...
I'm just thinking of the nature of the right of participation in elections and the effect of them. I don't think they were sort of agreeing with the proposition that it has no significant legal underpinning.
Well, Your Lordship, yes, Your Lordship might with respect be right about that. As long as it continues to exist, the attendant right, well, they talk about local government and its historical position. As long as it continues to exist, the attendant right to vote in these elections can be viewed as nothing less than basic and important.
But it's qualified in paragraph 79.
Yes.
I think.
Yes, they draw exactly the comparison that we draw between the existence in the Constitution of rules about the need for regular elections to the legislature, to the sovereign body from which the government is drawn, and local government. The trouble, the difficulty is, I mean, I think that the point I draw from it is that there is a difficulty with appealing in general terms, as respectfully we submit our learned friends do, to notions of the constitutional importance of the right to vote, including the right to vote in local elections, on a question of statutory construction. What you actually need to do is to identify something akin to, if I may be forgiven for going back to it yet again, because it's a good example with respect to your lordship's example about tax, something where here's a concrete thing, concrete right, that everybody agrees is part of the very fabric of our way of life, such that Parliament must be taken to have proceeded on the basis that it didn't mean to knock it out without saying so, and that's really where it goes. And perhaps I can just conclude on probably conclude my submissions, I think, a little ahead of time, subject to anything my learned friends might want to add, just by actually taking your lordships to Lord Sales's article, which we quote from in our case, just to set the passage that I rely upon in context. It starts at page 2248. I think we've made a slight error in our case. We've called it In Defence of Legislative Intention. I think that was the title of when it was a talk, and then when it turned into an article in the Statute Law Review, it got a rather duller title, as you can see from the top of 2248. But the context of the article is the notion of is defending the notion that there is such a thing as legislative intention, and the context of the passage upon which we rely you can pick up from around about it is really page 2257. And it's not just it's for the Statute Law Review, and it's for people who are interested in how Parliament works. It's not just about the sort of question that we're concerned with. It's about also how Parliament works in practice. But from about an inch or so down on that page, you can see from the intra-legislative perspective, the constitutional presumptions referred to by the principle of legality assist the efficiency of legislative deliberation, since parliamentarians can take them as read without having to introduce them to every debate on every bill. From the extra-legislative perspective, which is our perspective, I suppose, the subjects of law can rely upon the presumption that certain long-standing, well-recognised and important constitutional principles should be taken as read unless the contrary is clearly indicated in the legislation in question. Not just certain human rights or civil liberties, such as the right not to be tortured or free speech, etc., right to be treated fairly by public officials. The role is not so much to inject normative content into legislative texts, etc., but to see that the legislature and the executive have sufficiently held in mind the longer-term principles, rights and freedoms which support the moral claims of democratic rule when legislating to adopt a statutory text. That's why His Lordship goes on to say it's an aspect of the principle of legality is an aspect of legislative intent. And then the passage that we quote, it becomes highly relevant to ask whether any supposed fundamental right, which is to be capable of modifying the
where is that?
So I'm reading now from page 2257, about halfway down the page, on this model.
Oh, I see. It becomes highly relevant to
That's
ask.
right. On this model, etc., it becomes highly relevant to ask whether any supposed fundamental right, in inverted commas, which is to be capable of modifying the meaning of legislation, can plausibly be taken to have had such a level of acceptance among parliamentarians, and as may be evidenced by acceptance by other key constitutional actors, such as senior civil servants, as to form part of the legislative context in which they meant to act. One then needs to look for evidence of such rights and principles in constitutional tradition and in political practice and self-understanding, rather than simply asking whether a group of judges think them a good idea. The use of such evidential criteria ensures that Parliament, when it legislates, has fair notice of the way in which the courts may be expected to read the text it creates, and hence can formulate them to take account of this, and so be enabled to exercise legislative agency effectively. And His Lordship then goes on at the bottom to say it becomes a way of reconciling the traditions of the democratic tradition and the liberal human rights and rule of law tradition. But what's important in our submission for present purposes, when your Lordships are considering all of our learned friends' submissions about how you should not read the amending act in the present case as applying to incumbent councillors, because it doesn't expressly say so. What's important is to ask, well, is there in fact any, have you been shown any fundamental right about which it can be said, well, if Parliament had intended to override that, it would have said so expressly, because it's part of the context. And our respectful submission is the answer to that question is plainly no. There's nothing in the Constitution itself, we respectfully submit, that has that effect. And that's a very important distinction between the principle of legality as applied in a country with no constitution which purports to set out the fundamental rights which the nation regards as, well, the rights which a nation regards as fundamental, and a country where they do have that, and insofar as it may be possible for there to be some other sort of sub-constitutional category of rights in a country like Trinidad and Tobago, and I did say it's theoretically impossible, but one would struggle perhaps to find very many instances to populate that class. Has that been shown in the present case? Our submission is respectfully, no, it hasn't. Indeed, on the contrary, we can see actually that the notion of extending the term of existing councillors is entirely commonplace, albeit it's true to say, and this is the point in our learned friends' favour, it's true to say that in the past when Parliament has done it, it's spelt it out a bit more clearly than it did here.
But is it just a question of individual human rights? Because Lord Sales in this passage, although he focuses considerably on that, doesn't restrict his discussion to individual rights, but includes principles, longer-term principles, rights and freedoms, which support the moral claims of democratic rule. The effect of extending the term of an incumbent councillor, or the same with an MP, is or could be said to be an interference in the electoral process, in the sense that, not in the actual procedure of the election, but in the sense that the electorate have voted someone in for 3 years and now finds they're in for 4 without any, obviously it comes back to your basic point that it's all unambiguous, without the point being expressly dealt with by Parliament. So it's not necessarily a question of identifying an individual right in the sense of a right vested in each elector, although clearly there is that right, but more the whole democratic process.
Well, no, I would respectfully accept that it's not just a question of identifying a right that an individual has, and I equally would accept that I wouldn't suggest that's what Lord Sales is saying in this passage. It's about. I mean, here I agree. He's talking here about fundamental rights, but I think I would accept that there are practices and understandings about how things that should be done. I mean, he himself, when addressing the question of rights, says you need to look at. He talks about rights and principles in constitutional tradition. So I mean, I would accept that there is scope for this doctrine to operate on more than just a specific concrete right, like professional privilege or the right to a fair trial or whatever it might be. But in a constitutional democracy which has a written constitution, then one looks in the constitution for those principles and traditions as well. If one wants to know what is the settled understanding of the people of Trinidad and Tobago about the extent to which local government shall exist, and if it exists may be modified, one looks in the Constitution and all that one finds is that it's not there, and it's advisedly not there. As I mentioned earlier, I didn't take you to the reference, but it's in our case. This was expressly discussed in the report on the Constitution before the Republican Constitution was adopted. It's left entirely to Parliament. So the relevant constitutional tradition is that the existence of the existence of local government and the nature, the shape that it takes, is a matter to be determined by Parliament. And there is no particular presumption in that it is to take any particular form. And if I'm right that, as perhaps I'm in danger of repeating myself, but it's an answer to this point too, I would suggest, if I'm right that Parliament could simply do away with local government altogether as regards, either entirely or as regards some particular element of it, it must follow that Parliament can also make modifications to the modalities of exercise of local government, including the one that it made, we submit, in the present case. And it plainly is right that Parliament can do away with the aspects of local government. I'll learn friends, understandably for forensic reasons, talk about local government as if it was a sort of sacred aspect of the democratic process. But the core element of the democratic process is the election of Parliament, the legislature. How local government is then delivered is necessarily a much lower order question in our submission, because local government is not about, when you elect your councillor, you don't elect the person who is sovereign over you, subject in the Trinidad and Tobago into the Constitution. You elect the person who's responsible for a collection of things that statute has said should be done by that local authority. Taking away your refuse, making sure your roads are well maintained, etc., etc. And of course, it may be said it's desirable that those sort of things should be voted for, but even in other jurisdictions which are indubitably democratic, some aspects of those things are not done democratically. In the United Kingdom, there are many decisions about funding that are taken by quasi-autonomous non-governmental organisations because Parliament has decided that a body of local business people, for example, should have the right to decide how to spend money on a new building project, or a new roundabout, or whatever it might be. No one says in that context, well, my fundamental rights of democracy have been taken away. They recognise that we're dealing with a lower order question. So, I mean, the short answer to your question is yes, I entirely accept it's not just about fundamental rights, it's about constitutional traditions as well, and basic concepts of the rule of law. But ultimately, the Constitution leaves this to Parliament, and for that reason, there's really no basis for giving the Act that we're concerned with any different meaning from the one for which we respectfully contend. I'm grateful. Just before I give way, my Lord, just to answer the question about by-elections, I think the answer is section 29 of the Act.
Yes.
I think I have seen in the record some controversy about, I think it's in the original complaint, some controversy about whether in fact by-elections would be called, and some complaint that in the past by-elections hadn't been called, but the Act makes it quite, 719 is the page in the record. The Act makes it plain that the President shall issue a writ on being satisfied, so if the President didn't, then there will be a remedy in that regard. My Lord, unless there are further matters that you think I haven't attempted to deal with, those are my submissions.
Thank you very much, Mr. Rowe. Mr. Ramlogan?
No, thank you. Well, the problem with section 29, just to pick it up where we left off, is of course that the President shall issue the writ is also again on the advice of the government of the day. So it brings you back to square one in terms of whether yes, a by-election is possible, but the complaint, as my little friend quite rightly pointed out in the evidence, is that the government, by virtue of when it chooses and the power of delay, can, of course, leave a particular section of the community unrepresented. And that's part of the overall unfairness, because if a councillor or alderman who had structured his life on a 3-year term of service decides to resign, it's easy to say, yes, he pays the fine and he goes. But what about the people who are left behind unrepresented? As a result of that, I mean, that's part of the problem we must also grapple with.
But section 29 is quite clear in its terms. I mean, it makes it absolutely clear that the President is the person who issues the writ. Parliament must have drafted this on the assumption that it's advising the President would behave rationally, but...
Oh yes, no, the President issues the writ. The point I'm making is the President does so on the advice of the Cabinet.
Yes, but one must be assuming that the advice that the President receives is rational advice.
The problem is the delay, and when that advice is tendered, that's the problem. And as my learned friend has quite rightly pointed out, there is complaint about that. And it therefore leaves you naked, unrepresented, and exposed due to, when that wasn't part of the pact. My Lords, the first point I'd like to make is that the issue of when the law comes into operation is not really an issue that we take, that troubles us in this appeal. The question of when the amendments entered into force, we accept when the amendments entered into force, but that's not the question. It misses the mark respectfully. The question is, what were the amendments intended to apply to? Were they intended to apply to the incumbents or simply prospectively to future elected councillors and aldermen? That is the issue. And Parliament did not provide in express terms what should be the position in that regard. We say that the issue is not, in other words, when did the relevant provisions of the amending act come into force. It is whether, on a correct interpretation, it's reasonable to impute that Parliament, having amended the law, intended that it would apply to the incumbents. That's the issue. So the fact of proclamation and the fact that proclamation can take place at a particular point, and it has been proclaimed, but the problem is whether or not, having been proclaimed, what is the correct interpretation with the status quo that confronts it at the time of proclamation? I wish to make it clear that our submission on the constitutional right covering the right to vote, which we say there were two such rights at the time the Constitution came into existence, that is, if we are correct on that the right to freedom of political expression captures and gives constitutional recognition and shelter to the two rights to vote that were in existence at the time of the Constitution coming into existence, namely the right to vote at local government elections and general elections, then the principle of legality is squarely and frontally engaged. And we do not resile from that proposition that Section 4E, in its terms, captures the right to vote in existence at the time the Constitution came into being. And that right, the right to vote, was articulated via two mediums, general elections and local government elections. We say the Court of Appeal where we say the Court of Appeal went wrong is to restrict it to just national election, the general elections. And of course, as my Lord Richards quite rightly observed early on, it will also give rise to questions of deeper questions of proportionality and matters of reasonable justification. Now, one of the issues that arises from a learned friend submission is, if it is that we concede that Parliament that this can be done for 1 year, the question is, where does one draw the line? In the Court of Appeal and the courts below, the submission was made by the respondent that 20 years of postponement of local government elections or extension of office would be the line in the constitutional sand when it amounts to a frustration of the democratic mandate that is given. 20 years. But therein lies the crux of the problem. If you concede that this can be done without any form of, as my Lord said, there must be some rationality to the administration of the law and the process itself. The problem is it is a license that can lead to a frustration of the democratic mandate that is given. And we say, therefore, that even when one has regard to what has happened in the past, one has to bear in mind the submission we make, because there was no challenge before, but one has to bear in mind the submission we make about the constitutional context and the historical importance. We do say that even if there is no vested right, the question of unfairness is still relevant. And to make good that point, if I take you to page 403,
page 403.
Yeah, page 403, and paragraph 93. Yeah, of our submissions, we say there's a danger that whether right is vested can become a circular argument. And we say the Court of Appeal fell into error into that trap, because some of the reasoning amounts to little more than saying that because Parliament can take the right to vote away, it is not a vested right. We say the safest guide is the rationale behind the presumption against retrospective application, and that rationale is fairness. And we cite the case of Tunnicliffe, which is that the true principle is that Parliament is presumed not to have intended to alter the law applicable to past events and transactions in a manner that is unfair to those concerned them, unless a contrary intention appears. And it is not simply a matter of classification one way or the other. It may be a question of degree. And the greater the degree of unfairness, the more Parliament is expected of Parliament to make clear that what its intention. With respect to the point made by my learned friend that election is a process that culminates in an event, and that somehow creates uncertainty on our construction of the law. We say, look, our construction leads to no such uncertainty. Up to the time of the actual election, at any time prior to the casting of the vote on the day of election, we say that if the change is made, it will apply to that election, to the newly elected persons. That's simple and straightforward. Now, my Lord Briggs raised the point that 4 years might allow for more time to do good work. Well, that presupposes that it's good work, that the representative is a good representative, because more time for a bad representative wouldn't
been
persist.
elected, or she has been.
Sorry?
He or she has been elected.
Well, yes, but that's precisely why the
basic
term,
level of trust in the electorate.
well, that's precisely why the term of the election is so important, because they've been elected, but 3 years is the time within which you judge their performance and you can vote them out or re-elect them. But that's precisely why the term of office is so important from the perspective of the voter. Because you may, look, if by parity of reasoning, having them elected, having fresh people or a fresh mandate for a 4-year term may very well assist, or if we flip the script, may very well assist in a greater way.
Well, maybe one doesn't know, but it's perfectly possible to imagine a situation where an extra year would enable all of this other machinery to be put in place, and so 1 more year before the elections with the new machinery will save all the cost of having to carry out the election this time without that new machinery. So better, it may be thought, to wait until it can be implemented as a whole.
Well, that's evidently a very sensible point, provided it was articulated. And the point is, we've been through 2 courts below. We've been through lots of evidence, and that point has simply not featured anywhere in the respondents' evidence or submissions, as you will see from the both judgments and submissions in the court below. It's never been advanced by the respondent that there is some justification that is linked to the implementation of the reform, that this is why this is needed. And that's part of the reason why we say there's a certain amount of arbitrariness and irrationality and unfairness about it. Because they've simply not taken, that point has not been raised. But equally, my Lord, equally, if it were to be done for an ulterior improper purpose or motive, for example, if I don't want to face the electorate, given the political climate, or for some other reason, that is equally to be countenanced. Well, had that point been raised, I accept, of course, my Lord's point on it, had it been taken and had it been featured in the case at all. It just simply hasn't. My Lord Richards made the point that there's a vast difference between the legislature doing something and the passing of the baton to the government of the day to exercise powers that would result in A, extending the term of office, B, postponing the elections, and introducing a new term of office. These are three pretty grave matters. And to place that power in the hands of the executive without reference to settled principles of statutory interpretation, which we say, when applied, favors our construction, wouldn't sit easily. We say. Melinda Friend says it's a modest alteration. The word modest was used, it punctuated his submissions throughout. And we say it's not a modest alteration to the political arrangement to say that, look, you can extend it for 1 year by introducing a new term. It's not modest because it's an entire year, and also because when does it become immodest? If we concede that 1 year is a modest alteration, well, when does it become constitutionally immodest? 20 years as suggested in the courts below? 20 years? And insofar as my learned friend suggests that the right is simply not there in the Constitution at all, and therefore we should jettison that argument altogether, we say that the Trinidad and Tobago Constitution adopts the generic descriptive rights, and the courts are left to flesh out the messy detail of what those rights include. And our simple submission is the right to freedom of political expression. The messy detail of that right, when we flesh it out, ought properly to include not simply the right to vote at general elections, but also right to vote in local government elections. My learned friend says that which Parliament grants, Parliament can take away, and that's a cardinal principle. We say, yes, that might be true, save and accept that that's not the issue. Parliament can take away. The question is, can it do so by inference, given the nature of the right and given the constitutional implications? And we say no, Parliament cannot, by a legislative sidewind, by inference, take away the right to vote in local government elections. Now, my learned friend says that the board in Chandler and Suraj would have said that any such constitutional right cannot exist untethered from the Constitution. We say far from being untethered, it is a right that is located, the axis of the right is located squarely in the Constitution by virtue of the declaration that we are a sovereign democratic state. We say that this is not a right, this is not a case like Chandler and Suraj where you're dealing with a challenge to a saved law or a challenge to the right to bail and matters of that kind, and how would that impact on the concept of a sovereign democratic state. We say that this falls squarely in the heart and soul of the definition of a sovereign democratic state. For what is a democratic state without the right to vote? And therefore we say that Chandler, Suraj, and the death penalty line of cases are all to be distinguished because it deals with something quite different. Insofar as my learned friend says we cited other jurisdictions, the table is to be found at page 105, and the short point about that table at 105, we started off at page 104 to show what the practice was in the United Kingdom when they postponed local government elections in the height of the pandemic, and we then went on to at the bottom of page 104, this is what the Local Government Police and Crime Commissioner Coronavirus regulation stated, and it stated that the poll is instead to be held on the ordinary day of election in 2021. A councillor who would otherwise, pursuant to the relevant order or resolution, retire on the 4th day after the ordinary day of the election is instead to retire the 4th day after the ordinary election in 2021. And then we have the table doing a quick roving review around the world. And what we see, the short point is that clear and express language was used to extend the term of the incumbents whenever this issue arose. So that there's an international consensual approach when it comes to sensitive matters pertaining to democracy and the right to vote, that clear and express, unambiguous language is used. And we commend, therefore, that point which arises out of that table. There has to be some higher philosophical approach on the facts of this case. Parliament cannot debate a bill that deals with a proposed package of local government reform. And there is no question raised by anyone to suggest that this is something that is meant to be retrospective or to apply to the incumbents, and to take away a right to vote or to postpone an election. And then by virtue of a proclamation that comes afterwards, all three things are accomplished. In ex parte sims, when it is said that Parliament must know what it is doing and confront what it is doing, because it must face the political cost of what it's doing. Those are higher principles upon which our democracy would be based. And it cannot be right, there is no integrity in the legislative and democratic process if Parliament can debate and intend one thing, and by virtue of the proclamation by the executive, well-timed or ill-timed, achieve something quite different, which Parliament could not possibly have intended or contemplated, as the case may be. And we say, therefore, that there must be some higher principle, which we say was outlined in ex parte sims, about Parliament knowing what it is doing, confronting what it is doing, intending what it is doing, and paying, most importantly, the political cost of it. Oh yes, my lord, the Bombay case, Chavan, we've dealt with it in our written case, and we say that there's a paucity of reasoning in the case when one reads it. There are errors that are obvious from perhaps the Google translation of the judgment, perhaps, because if you read it carefully, you will see that parts of it are incoherent and does not make sense. And if you look at the use of commas, for example, you will see that it's wrongly placed in several sentences that simply don't make sense. But more importantly, in that case, there was an express provision to extend the term of the president. There was an express provision for the municipality to do that. And in that case, the Amendment Act, which extended the life of the municipality to 5 years, the court simply held that, look, the tenure of the president was not extended by the municipality, and in those consequences, the substantive act which extended the life of the municipality did not ipso facto operate to extend the tenure of the president. I mean, that's what it is. But insofar as it says that there's no vested right in the duration of the office, it didn't confront the issues that we have raised about the vested right to vote, the vested right and obligations from the perspective of the elected persons, and there is an absence of reasoning in the case. We have dealt with it in our written case, and we will stand by those. We stand by those written submissions. Oh yes, my lord. My junior quite rightly reminds me, Section 2.2 of the Municipal Corporations Act, which I think we've went it before, but it states that page 701, the day on which the councillors of a corporation were elected means the day or last day, as the case may be, on which all the returning officers within the municipality have declared their respective candidates to be elected as councillors. That is there because there may be actual variations in the dates, depending on, for example, if there's a recount and so forth. So it just fixes the commencement of the term as a common denominator forward. Yes, and that connects with the deeming provision in 11.4. My lords,
I think that does explain the deeming word.
It does indeed, my lord. Thank you very much. So, lords, unless there are any further questions, those are our submissions, and we'll ask that the board grants a declaration in the following terms: that the relevant sections 3C Roman numeral 3 and 3D Roman numeral 3.
Hold on, I'm just taking a note.
Sorry.
Just taking note of this. The relevant sections.
Yeah, we ask a declaration that the relevant sections 3C Roman numeral 3 and 3D Roman numeral 3. So that's 3C Roman numeral 3 and 3D Roman numeral 3 of the Amendment Act which came into force on November 8, 2022. Did not extend the term of office for the councillors and aldermen who were holding office as of the 8th of November 2022. We also ask for a declaration that the local government election was due to be held on between December 4th, 2022 and March 4th, 2023.
Between December
4th, 2022 and March 4th, 2023.
Is it March the 4th or March the 3rd?
It's March 4th because when one has regard to it's clear days under the Interpretation Act, so that's why.
My friend says election to be held. Does he mean when the writ should be moved for it, or does he mean the actual?
No, I said was due to be held. I said was due to be held because I think to vindicate the rule of law in this case, a declaration to that effect would at least prompt the appropriate action and response, and that's why we asked for it. Yes, and it's also consistent with the wording in section 11(4)(a) of the Act. I'm deeply obliged to my lords. Thank you very much for your time.
I don't know, but I rather imagine that if we were to grant a declaration in terms of the first declaration sought, there might then be questions as to the legal effect of acts of a local authorities subsequent to 8th of November 2022. But we're not being asked to address those questions at present.
No, my lord. But I suspect that the doctrine of executive necessity and the de facto officer doctrine may provide an answer.
Yes, I was thinking along those lines as well.
Yes.
Could I just make a suggestion that if your lordships were minded to, in broad terms, decide the case in my learned friend's favour, albeit I appreciate time is very short, it might be sensible for there to be short written submissions as to what relief ought to be granted in the light of that, so that we don't end up in a situation where the lordships say something and then there's litigation unnecessarily in Trinidad and Tobago as to what it means in practice.
My only concern about that is I was going to end on the note that we started, which is I thank the board for deeming this appeal fit for urgent and expedited hearing, and that sense of urgency still exists, obviously.
Yes, of course.
And I wouldn't want. Whilst I appreciate the onerous schedule of the board, I would ask that we be given some special consideration have regard to the nature and importance.
Well, I'm very mindful of this. I suppose. I mean, at the moment, this is all hypothetical, but if we were with you, then we could allow the appeal.
Yes.
And which would obviously send a very clear signal, and at that stage invite submissions on the terms of an order, and set, say, 7 days and 7 plus 7, and then issue an order. Because in any event, any fresh elections couldn't be held at the drop of a hat.
No.
In any event. I assume that's right.
That's right, and that's right. I mean, time is of the essence, but I have no objection to that. I mean, I presume, if a judgment articulates the findings, we can certainly, the state of Trinidad and Tobago will be guided by those findings, pending the finalization of an order 7 days by 7 days might be a bit too much. I was more thinking along the lines of, you know, a much shorter time frame.
We're in a lot of hands as to what time would be, but I certainly wasn't suggesting 6 weeks or
No, I appreciate
submissions. But I mean, I'm not sure my friend can insist on submissions about what's clearly, if my friend's persuaded you on the principle, on submissions about what's clearly quite a tricky issue on anything less than about 7 days per party. Yeah. We're in circumstances where, my friend's right, there's already been a degree of delay beyond when the election should have been. And there's going to be a bit of further delay because under the terms of the Representation of the People Act, there needs to be the issue of the writ nominations 14 days after that, the election 21 days after that. So the election, as your Lordship says, it can't be done at the drop of a hat anyway.
Yes. Well, we're acutely conscious that this is a matter that needs to be dealt with expedition. We've heard substantial arguments on both sides. We're not going to be able to give you an immediate decision here and now. We'll endeavour to produce a judgment as soon as we can, and then announce our decision on the appeal. And it rather sounds as though at that stage we will have to set a timetable which will have to be quite short for submissions on the form of the order.
We're deeply obliged, madam.
Well, just before the board rises, may I just pick up on what I said earlier about the evidence about the reason given by the government for bringing the Act into force, the Amending Act into force, and on the date when it did. And I don't want to waste time now developing any submissions about it. But I think I said I would come back to it. May we send that in the next day?
Yes, that'll be helpful.
I'm not proposing to put in any fresh evidence. This is material that was before the courts below, but which hasn't made its way into the record. Partly because I think we agreed it would be dealt with as a matter of construction. But as the argument has developed, my learned friend has sought to place reliance on other matters. So, so far as your Lordship want to look at that, you should see the whole picture.
Yes, very well. Well, we're very grateful to all counsel and those who've assisted them, and we'll give you our decision just as soon as we can.